The campus of North Idaho College and today's broadcast of the North Idaho College Public Forum. The crew is comprised of North Idaho College television students. Your moderator is North Idaho College political scientist Tony Stewart.
Good afternoon, ladies and gentlemen. With today's program, we're so happy to report to you that we're starting a 6-week series on a subject that we think will be of extreme value to you. The subject is Know the Law. In order to carry out that, we have divided our series into 6 different important subjects. We know there are others, but we selected 6 that we thought you might be most interested in. In order to carry this 6 weeks program to you, we're happy to join with the Kootenai County Bar Association, which is co-sponsoring these 6 programs. Also on 2 of the programs, we're happy to have the cooperation of the Spokane County Bar Association in order to bring the programs. On our first program, the topic is going to be landlord-tenant laws. In order to discuss that important subject, we're happy to welcome to the program 3 attorneys. I would like to introduce to you, first of all, Norm Gissel, who is an attorney with offices in Coeur d'Alene. Our second guest is Alfred Kitching, who has his law office in Spokane. And the third guest is Chuck Cherokee, who is also an attorney in Coeur d'Alene. Gentlemen, welcome to our program. We're excited about the series, and we're happy to start with you. I am welcoming to our program today 2 panel members. First of all, regular panelist Lou Reed, who is with us most of the time, and also returning for an appearance and been here several times before, the Assistant Director of Vocational Programs at North Idaho College, Bob Brown. I would like to invite Lou Reed to commence the questioning.
Thank you, Tony. I would like to ask Chuck and Norm what the present status of landlord-tenant laws, what the status is in Idaho. Are these laws in need of reform, or are we in pretty good shape? Why don't we start with you, Norm?
Well, I think the laws in Idaho with respect to landlord-tenant are in excellent shape. This wasn't the case about 5 years ago when all of the law that was on the books was weighted in favor of the landlord. There was a landlord-tenant law that was passed that gave the tenant many extra rights that he did not otherwise have. And as a result, I think there's a fairly good equitable balance between landlord's rights and tenant's rights.
Do you agree, Chuck?
I agree for the most part. I think the problem with the present laws is that they have been drafted so broadly, and they are up for judicial interpretation. I therefore think that it's incumbent upon tenant attorneys to go into the courts and to definitely establish what rights the tenants have.
So this is a question of interpreting then these new laws, but you would agree that the laws themselves are strong, they just need to be backed up.
Yes.
Oh, that's very good. Al, can we ask about Washington?
Yeah, I think the situation is probably the same in Washington. There was a long history of landlord abuse of his bargaining position so far as the tenant was concerned, as a result of which the legislature drafted a law which was meant to try to balance out those positions. And it pretty much has done that. It's drafted the statute in such a way that the tenant, for the rent that he pays or she pays, is entitled to what's called a habitable dwelling. Habitable dwelling is defined by the statute as meaning several things which the landlord is obligated to provide the tenant under that law. And on the other hand, the tenant is obligated to pay the rent. And it pretty much has established a pretty good balance in Washington. The only big difference is that the landlord, if he wants to enforce his rights, has to go to court and pay money, whereas in the tenant's case, most often the tenant's in a position to withhold money from the landlord to enforce those rights. And that sometimes results in this imbalance, I think.
That's very helpful. We may want to pursue later a little bit more about habitable dwelling, but I'll, in the meantime, defer to Bob Brown.
I'd like each of you to comment on what, in your opinion, is the most common problem that you have encountered in landlord-tenant relationships, and what suggestions could you give a tenant to how to avoid this common problem? In your experiences as attorneys, what is the most common situation that you find come to your office in landlord-tenant relationships, and what suggestions would you give a tenant in order to avoid this conflict? And Chuck, let me start with you.
First of all, I'd like to say I work for legal services, and I specialize in housing, so therefore I deal constantly with landlord-tenant disputes. I'd say by far the most chronic problem is security deposits and what exactly they involve and entail. I think that many landlords have the misconception that security deposits can be used for a wide variety of reasons. They can only be used to pay for any damages which the tenant may have inflicted upon the premises. And now the problems that we run into are generally these, that there is a dispute as to who actually caused damage, whether it was a prior tenant, was it a pre-existing problem or not. And I think the best way to resolve that would be when you are about to rent an apartment, that you go in with the landlord and examine the apartment and make a list of all pre-existing defects in the apartment, so that you will have a list of all problems that have occurred prior to your tenancy, and therefore you can have an established record of what was wrong beforehand, and that would save an awful lot of conflict in the future.
Yeah, I would pretty much agree that security deposits is an area of a lot of landlord-tenant disputes, and it actually is a problem from both the landlord and the tenant side, because it's very difficult sometimes for landlords, say, to prove what damage has been done to a dwelling unless he makes the kind of itemization inspection with the tenant that's been suggested. On the other hand, I think so far as the landlord's concerned, the main problem facing him is sometimes an inability to get his rent or her rent. Those are kind of the two basic problems I think that face landlords and tenants, are damage deposits and trying to get the rent.
Norm?
I would agree with the statements of both the other attorneys. The problem of non-payment of rent, at least in my experience, generally is a result of the breadwinner of the family losing his job. And there is an awful lot you can do about that. And that's very difficult, because if he's lost his, just say the husband's the wage earner or the breadwinner, and he's lost his job, he not only can't pay the rent for the apartment that he's presently live in, but he can't pay the rent for any other place that he might be willing to move to. So as a consequence, he's in a very tight and difficult position. Yet at the same time, he has a contractual agreement with the landlord to make the rent payment. And the landlord, the typical landlord in Coeur d'Alene is a small investor who has maybe 1, 2, or 3 houses, and he has to have that rent in order to make the payment to the person who he purchased the property from. So you have a vicious circle there, and many times it's very difficult to reconcile those two conflicting interests.
Gentlemen, I would like to ask a question concerning rent payments. I know that comes up quite often. The question deals with the renter not paying the payment at all or making the payment late, and the other part is when there is an increase in the rent for a future month. What are the procedures to deal with all of this on the behalf of the landlord? And we'll start with you, Mr. Kitching.
In Washington, the basic procedures, the statute in the state of Washington is really the contract between the landlord and the tenant, so far as the rights and obligations are concerned. And that statutory contract really can't be modified without a lot of different special procedures, like asking the permission of the Attorney General. So the law has been stated, and it provides for notices. And in the case of non-payment of rent, the landlord's in a position of giving a 3-day notice to pay the rent or get out. So far as a rent increase is concerned, it's usually a 30-day notice before you can increase the rent. That is essentially the steps that have to be taken by a landlord, is he must first give the particular statutory notice that is relevant to the problem the tenant's having, in this case rent.
Excuse me, now on the late rent, if the rent is due on the 5th of the month, he would have to notify him after that date and still give 3 days, is that correct?
Right. It's 3 total days to comply with the notice, which says to pay the rent that you owe, or if you don't do that within that 3 days, you have a whole 3 days, from 3 days from the time you get the notice as a tenant. And if you can't pay the rent within that time period, then the notice says get out. Of course, the landlord can't just kick him out. He has to go to court also and get a court order.
Mr. Gitzel, what is the situation in Idaho?
Well, it's quite similar. If a landlord has not received his rent, he's entitled by Idaho statute to give a 3-day notice to the tenant, hopefully serving him personally, and if not, there's procedures for doing it otherwise. And in that notice, there is a requirement that he has to vacate or pay the rent within a 3-day period of time. And if he does neither of those two things, then the landlord has the option of going into court and seeking his eviction.
How about increasing rent, Chuck? How long does one have to notify ahead of time to increase rent in Idaho?
Well, of course, if you have a lease agreement, then they can't increase the rent during the term of the lease agreement. If there is no lease agreement, I believe the provision is that they have to give a 15-day notice prior to any increase in rent. One thing I'd like to bring up that is an area of confusion for many people in Idaho is that regarding the non-payment of rent and the 3-day notice, that after the expiration of the 3-day notice, that does not mean that the landlord can come in and physically evict the tenant. What he must do then is file a complaint, set up a hearing, and then litigate the issue in front of a judge, and then obtain a court order before an eviction can occur. Now that's a matter of dispute in Idaho, and I think that should be made quite clear.
Lou Reed.
When we talk about tenant rights, what really are we talking about? I think you've referred to some which have to do with notice and the whole question of protection in regard to some of the deposits. What are some of the other areas that you consider tenant rights? And perhaps this brings up again the question of habitable dwelling.
As Al stated, for Washington, it's the same in Idaho. There's certain criteria, but essentially what the statutes in Idaho are talking about is that if a landlord's going to rent a house, it has to be a habitable house. And if it's not habitable, then the tenant has similar 3-day notice rights that we've previously discussed that the landlord has. He has 3-day notice provisions himself, which he can use to, in effect, force the landlord to provide a habitable dwelling.
Well, let's put this in sort of ordinary terms. Like if you have a leaky faucet, if you have a drafty window, are these all things in which you have the right as a tenant to go to your landlord and make a fairly much of a demand?
Yes, they are. The statute lists specifically the areas which must be maintained at all times, and they are generally the most basic facilities: plumbing, sanitation, weatherization are the main areas that must be maintained by the landlord. And one thing I would like to bring up is that one piece of legislation that I had hoped would have been enacted was prohibiting retaliatory evictions. And that is, when the tenant sends a 3-day notice listing repairs that should be made to a particular structure that he's renting, a lot of times the landlord, in order to circumvent the law and try to avoid liability, will turn around and attempt to evict the tenant so he will not have to make those repairs. There is no statute prohibiting that. However, there have been judicial interpretations through litigation that have recognized the right of the tenant to have these things done without being faced with an eviction, and have upheld the idea, the concept of prohibiting retaliatory evictions.
There's something that I have just learned. I had not realized that the statute actually created a statutory contract. And this is true for both states then, that there's a checklist within the statute itself. Then does someone who is renting month by month then receive a copy from the landlord of the statute? And is that part of the requirement, so that tenant is then aware of the statutory contract?
No, there's no requirement that the tenant be made aware of his rights. It's up to him to learn his rights. And
So it's rent or beware still.
right.
Bob Brown.
I'd like to talk about some of the uses and enjoyment of property by tenants. Specifically, for example, some states have been in a direction, a drift perhaps, of outlawing the prohibitions against having children. You know, many apartments will say no children, no pets. I understand that's been challenged successfully in some states. I don't know if it's all court cases or if it is just legislation. What are some of the situations in Idaho and Washington concerning the restrictions like that on renting? Can you, in fact, restrict pets, children, this type of thing in both states?
I'm unaware of any case law in Idaho, and the statute does not limit the landlord's rights in that regard. And Chuck might have found some cases, but I'm unaware of any where if it's clearly stated that there are no children allowed in a rental complex, or dogs, pets, things of that nature. I think that the landlord can do that. By doing that, of course, he restricts the people who might otherwise rent from him, but if he's willing to run those types of risks in his business, I think he can go ahead and do it.
Well, that's correct. I know of no statutory prohibition against anything like that. I know of no case law holding that cannot, those types of things cannot be prohibited. I know that that was litigated in California, and that it was held an infringement on the rights of the tenant to be prohibited. I think that case was dealing with children. Mm-hmm. My feeling is that in Idaho, if it is particularly stated prior to the beginning of the tenancy that there are to be no children, that it will be upheld by the courts.
So far as Washington's concerned, it's pretty much the same situation. I'd like to comment on the retaliatory eviction thing that was mentioned. In Washington, we do have a statute which gives a presumption if a landlord tries to evict somebody within 90 days of a legal action taken by the tenant that is in fact a retaliatory eviction, and a tenant can recover damages, which is the legislative provision which I guess is lacking in the Idaho law. So far as whether or not children or pets can be excluded, I think to begin with, you're talking about two different things. I think you can always exclude pets because the use of the premises is going to be much different with a pet than it is with tenants who do not have pets. And I think the landlord has the right to restrict overuse or abusive use of the premises. And so far as children are concerned, I don't know of any case law which says that, like the California case, that a landlord must take children. I think there might be a constitutional argument of some sort, equal protection, that landlords in the state of Washington might have that same obligation. The big problem is, however, there is also a corresponding obligation on the part of the tenant to control their children, to make sure that the kids keep quiet, to not disturb the quiet enjoyment of other tenants' use of the property also. So, and see, the landlord is put in a very untenable position of having to enforce that right against the tenant, because that's his promise to the tenant, that he can enjoy his premises quietly. If another tenant has a noisy kid, for example, the landlord is forced to either evict that tenant or have the other tenant who's bothered by the noise sue him.
One final comment on that. We just went through an election, of course, and one of the comments I heard several times during the election was that I can't put a political sign in my yard because I'm renting the house, and the landlord says that I can't put a sign up for, a Republican or for a Democrat or whatever. If you have a comment on that, if you're renting an apartment or renting a house, can you put up a sign if you choose?
I would think so, yes. You're entitled to, the unfettered use and enjoyment of the premises, and that would include the yard unless it is specifically restricted. So in most cases, in practically all cases, it includes the yard, and you can do whatever you want with that yard as long as it's not anything destructive. And of course, placing a political campaign poster in that yard would not be considered a destructive act, and I think you would be entitled to do it.
Yeah, I would agree.
I think so too.
I think there's a big difference between putting a sign in your yard and setting up a loudspeaker system. So, but other than, you're talking about First Amendment and the right to,
One of the apartment units, large units, said that they had a rule that no signs could be in the windows of the apartment. No political signs could be in the windows. And that struck me as an odd rule, and then people had also told me that they could not, the landlord put a sign in their yard for someone that they did not particularly support, and they were afraid to remove it because they thought that was his right to do that. So I was just...
Well, now they know better.
Yes. Hopefully all those folks are watching.
Well, let's get into another area at this time, and that deals with housing that is both privately owned and rented, and others that is subsidized with either state or federal funds. What are the differences in the rules concerning tenants that live in subsidized housing versus all private housing? Norm, would you like to take that?
Well, Chuck and I just got through litigating that, and Chuck got through educating me on that. As I understand it, in the particular litigation that Mr. Shiroki and I was involved in, I found out to my great distress that the 3-day notice of eviction that we commonly give to tenants in private housing has to be extended to a 10-day notice with additional provisions when there is a HUD rental agreement or a HUD subsidized housing. So that's the chief difference that I noticed. The federal government, generally speaking, will allow a landlord to conduct his affairs, but in this particular instance, a 10-day notice seems to be proper under the applicable HUD regulations.
And the federal regulation would take precedent over any state regulation.
It always has so far.
Yes.
It did in this case.
Chuck, would you like to add anything to that?
Well, I think when you're dealing with subsidized housing, of course you're dealing with low-income individuals. And I think it's imperative that they be granted an additional safeguard simply because of their financial background. If they are evicted from subsidized housing, it's very unlikely that they're able to afford anything else. So in many cases it comes down to a last-ditch effort, and because of that I think the rules are somewhat more prone to an amicable settlement not resulting in eviction, and I think it's quite good that that's the case.
Mr. Kitching, I assume that I can state that whatever HUD has its rules, they have the same in all states, so it apply to Washington as well as Idaho.
Yeah, I would only add that although I agree that people who are in subsidized housing are in a unique position, and the landlords are too because of the federal law and the money that's coming from the federal government, I also think that at least right now, it's my experience that most people that get evicted from their where they're renting often have a very difficult time finding another place to live, because most often I think people get evicted because they don't have the money to pay. So.
Lou Reed.
What about the issue of liability? If someone falls on a sidewalk and takes it to court, is this something that is a responsibility of the tenant or the landlord, or is this spelled out in this new statutory contract? Chuck?
Well,
Who's responsible?
It would depend upon the type of structure it is. If it's a residential structure, I would think that, and as long as it would depend upon the contractual relationship between the parties. Generally, I would say in the normal contract, it would be the responsibility of the tenant to maintain the sidewalk, unless it's otherwise specified in the lease agreement.
Is there any disagreement on that?
I think there's a residual liability of a landlord in a slip and fall case, and he's out there making money off this particular piece of property, and he knows its condition, and I think he has certain liabilities to the general public to maintain a safe premises, and any of the landlords that I represent, one of the topics of discussion is to have adequate insurance which covers these unfortunate occurrences.
So you would recommend that the landlord, you do recommend that the landlord has adequate insurance. Do you also feel that if there is an issue or a question, such as Chuck suggests, that do you recommend that tenants have renters insurance covering both liability and personal property?
Definitely.
Is that true for you too, Albert?
Yeah, I would think the way things are, it's a little, I believe at least, that it's a little ambiguous under the Washington law. Under the statute, the landlord is given responsibilities to maintain the common areas, which are areas, generally speaking, used by tenants and other tenants. But that doesn't really address the problem of a single-family dwelling, which is being rented out, where the landlord, in theory, if he's responsible for the common areas, is going to have to keep the sidewalk shoveled, whereas the tenant's right there. The basic liability issue is who's got notice, who has notice of the problem, and in terms of who has that notice, who has the responsibility to correct it. I think sometimes in a single-family residence situation, the tenant really is in a better position to have notice of what's wrong with the property and take care of it.
Bob Brown.
Seems to be quite an increase in the number of unmarried couples who rent an apartment together or a house. I've had it stated to me that in Idaho, that if you hold yourself out, if a couple holds themselves out for purposes of renting an apartment or a house as a married couple, that under the common law common law marriage rule in Idaho, that they are in fact married. Would you like to comment on that?
Well, in Idaho, that's unlike Washington, by the way. Idaho does recognize the common law marriage. We have obviously a 4 or 5 hour time period to discuss this. In Idaho, you have to have capacity, and that means either of the two parties has to be single. You have to have intent, and that's what you're talking about, is intent. And there has to be a holding out of a marital state, and this can be proved by a whole variety of ways. And very quickly, filing joint income taxes, having the same mailing address, common knowledge among your friends that you're married, introducing yourself to total strangers as this is my wife, Joan, this is my husband, Bill. So it's not a single thing like going up to a landlord and saying, my wife and I would like to rent this apartment. Is not necessarily going to make them man and wife. It's one of the indices, and it certainly is evidence that they're married, but they're not necessarily married.
I must interrupt here. We're out of time. What you've done, Norm, is you've built the bridge to one of our other programs that we're going to have later. And I'd like to inform our viewers that this is the first in a 6-week series, and 1 week we're going to deal with domestic relations, another week with bankruptcy, and one with consumer purchasing, one with wills and estates, and one with defendants' rights. And we've got off to a good start, and I want to thank all three of you gentlemen. It's been a most informative program, and I know you've given our viewers many points that they would like to know about. Thank you very much. I also express my appreciation to the panel. Ladies and gentlemen, our guests have been attorneys from Spokane and Coeur d'Alene. They've been discussing landlord-tenant laws, and please be with us again next week for the second in our series when we'll be discussing the question of bankruptcy overview. I hope you have a nice week. I am Tony Stewart.
The North Idaho College Public Forum can be seen at this same time each week over this station. This production was videotaped earlier by a North Idaho College student crew for viewing at this more appropriate time.